Thanks for coming. Ladies and gentlemen, 25 years ago yesterday, a 10-year-old girl was in her home on the west side of Elkhart a little bit after 11 o'clock p.m. where she had fallen asleep on the couch after watching television. Her older brother had already gone to bed and her parents had gone out for the evening. And as I say, sometime after 11 o'clock p.m., she was awakened by a loud crash at the door and discovered an unknown male approaching her. This gentleman, probably the wrong choice of words, this individual threw a coat over the child's head and abducted her from the home through the front door. He then proceeded to take her outside into a waiting car where he drove off, taking her to a wooded area where he proceeded to rape the child. Following the rape, the unknown man dropped the child back off in the neighborhood and she went back into her house, went up to her bedroom and waited, and later was discovered by her parents having been emotionally traumatized and considerably injured as a result of the sexual assault. She was taken to the emergency room and samples were taken from her, and the Elkhart County Sheriff's Department in its investigation also took samples of items believed to contain biological material that might later assist in its investigation. That information was sent to the Indiana State Police in anticipation of eventual testing. However, the difficulty of the investigation was that there was no one to arrest. The investigation went cold. There was no one identified as a suspect at that time. And so the case did in fact go cold. Moving forward into 2011, the now adult victim contacted the Elkhart County Sheriff's Department to inquire about information concerning her rape as a 10-year-old child in 1988. She made contact with Diana Hoke, who is the administrative assistant for the sheriff. Ms. Hoke was very helpful in providing information to the victim and was able to locate material from the old file. Ms. Hoke had identified that prosecutor's investigator Gary Kinnewell, who currently works in my office, had worked on this case in 1988 as a detective for the Sheriff's Department. And Ms. Hoke contacted investigator Kinnewell to advise him of the inquiry of the now adult victim. Investigator Kinnewell reviewed the information he was supplied and did recall the case, and based upon that information received authorization from me to proceed with further investigation into the matter. Through investigator Kinnewell's investigation, he was able to determine that the Indiana State Police still maintained the items that had been collected with hopes of securing biological material from those items. And that's quite incredible in and of itself, given the nature of the case. He was also able to determine from ISP's very diligent work in this matter that there was sufficient biological material in order to make a determination of substances. With that, there was a request made for continued testing. Testing resulted in DNA matching the then 10-year-old child, as well as DNA that came from an unknown male contributor. Now, there's a whole lot of difference in testing and sampling from 1988 to 2011 and 2012. And the good news in any case of this magnitude in terms of an old case is that someone had the presence of mind to preserve samples that could not possibly have given us good information or this type of information as it does today. Those samples were preserved. So this could not have been done in 1988 based on the testing that was available at that time. Testing was done, and in the fall of 2011, we received a preliminary information, an investigative lead, if you will, suggesting that the DNA was a possible match subject to a confirmatory test. Based upon that information, we secured a warrant to get a testing sample from a suspect, and last month on February 13, we received information that to a reasonable degree of scientific certainty, a DNA match has been made. That match came back to an individual by the name of Robert E. Quinn. Robert E. Quinn is an individual who is currently in the Indiana Department of Correction, where it appears that he's serving time on a parole violation through a child molestation conviction out of Elkhart County. He has a scheduled release date as soon as June of 2013. Based upon the information that we have secured and through this investigation, I've authorized the following charges: rape as a Class A felony, child molestation as a Class B felony, and criminal confinement as a Class B felony. The 2 B felonies could subject Mr. Quinn to a possibility of an additional 20 years in prison each, and the Class A felony rape is a possibility of up to 50 additional years in the Department of Correction. I would like to stress that despite the information that we have here today, we must remember that all persons are innocent until proven guilty in a court of law. We're very pleased to be able to begin the process of completing this case and getting it started, but I would caution all to wait until we've had an opportunity to proceed fully in trial before making any determinations of guilt. At this point, we've made charges, and it's our anticipated hope that we will bring justice in this case. Any questions?